everybody. On behalf of Baker & McKenzie and the Global Trade team, I'd like to welcome you and thank you for joining this panel on sanctions responses to the Russian invasion of Ukraine. This is the start of our second and last day, fourth installment of our six-part series for our virtual trade conference. Hopefully you were able to join us for some of the sessions yesterday on export control updates, customs, and China trade developments. Today, we're going to wrap up with this first session on the sanctions against Ukraine, followed by Russian counter-sanctions, and a final session on enforcement developments later today. My name is Alison Stafford-Powell. I'm a partner in the California offices, and I'm very pleased to be joined by my colleagues, Brian Kasich from our Toronto office, Terry Gilroy from New York, Ben Smith from London, Hannah Steper from our Kiev office, and Anne Pettit, who has very kindly stayed up extremely late, not in her pajamas, to join us from Sydney for our APAC team. A couple of very quick housekeeping notes. If you're looking for the materials, Liz will post a link in the chat momentarily, or you can search your emails for an email from Baker McKenzie on Tuesday for the Global Trade Conference slides. We do encourage questions. Please use the Q&A function for that. And in the interest of time, we will try and address as many of those at the end of the session. If we don't get to you, apologies, and we will get back to you via email separately. For those that need recordings of any of the sessions, those will be made available on Friday following the conference and will be emailed out. We will be giving a CLE CPE code at the end of the presentation today, and information about how to claim CLE, CPE, CCS, etc. credits did come out in the communication on Tuesday with the various webinar links. Please do send those back within 72 hours of the completing each session so that you can get the necessary credit. Lastly, as this is virtual, there may be some background noise. There is a man who has decided to start mowing the lawn outside my office window just as we started, so apologies for that. So let's get started on this session today. This is a sanctions update, and given everything that's been going on and how we've all been spending our time since February 24th, we are going to focus this session on Russia. It's been keeping us, and I'm sure most of you, very busy, busier than ever, and still does. There were some developments indeed this morning and overnight that we will need to didn't have time to update our slides, but we will address in this session. Obviously, this situation has changed the security landscape of the Western world, and no doubt for at least a generation. It's shaken many of us, including folks inside Russia, to our core. We've seen new sanctions tools. We've seen a new era of multilateralism, and we don't appear to be done yet. So these are extraordinary times, and it does require extraordinary expertise and professionalism and a holistic approach to compliance. So your roles, our roles are really front and center here. So with that introduction, I am going to turn it to Terry and ask him to kick off first with an overview of the key sanctions developments, and then we'll go into some of the thornier areas before turning to Hannah and Anne for the Ukraine and APAC perspective. So Terry.
Thanks, Alison. And we thought it just made sense at the start to sort of, I guess, set the landscape in the United States, Canada, and the UK, EU, as to sort of what the sanctions look like from a high level. As Alison said, a little deeper into some of the issues that have been challenging to our clients over the last several months. one of my colleagues remarked a while ago that it feels like 15 years worth of sanctions sort of crammed into 3 months. And I think that's right. Notwithstanding that, Russia still is not a comprehensively sanctioned jurisdiction. There are plenty of activities, commercial, et cetera, that US persons can engage in Russia. But the breadth of restrictions that have been put in place have made compliance with the Russian sanctions, in particular for companies that have operations in Russia, very challenging. So up on the slide, you see sort of, again, at a high level, the categories of measures that the US government has implemented with respect to Russia. And certain of these will go back to the 2014 timeframe. Certainly there have been Russian SDNs prior to the invasion of Ukraine. We're all very familiar with the sectoral sanctions that were put in place following the annexation of Crimea, along with the comprehensive embargo on Crimea. But since the invasion, clearly there has been not only additional sanctions imposed in those categories. So there's a massive amount of SDN designations, a comprehensive embargo in the so-called Donetsk People's Republic and Luhansk People's Republic of Crimea, some additional sectoral type sanctions, for example, to Russian railways, similar to the sectoral sanctions that we had previously dealt with respect to the financial, energy, and defense sectors. But adding on to that, we've now seen targeted services prohibitions, which we'll dive into in a bit more detail later in the program. The new investment prohibitions, which have been very tricky, very broad export controls to include restrictions on luxury goods that really expand beyond, at least for U.S. persons, beyond goods that are subject to the EAR, and we'll talk about that in a bit. And then also the import bans on certain Russian origin products entering the U.S. And these measures, in particular the SDN designations, have really had an impact on dealings in certain sectors within the Russian economy that even aren't necessarily targeted sectors. So, for example, the Russian retail sector, as we've been helping out a number of clients over the last several months, it's become clear that a number of the Russian oligarchs that have been designated as SDNs have ownership interests in some of the, for example, well-known retailers across Russia. And while these entities themselves have not been subject to designation, we've had clients spend a lot of time trying to figure out whether their counterparty in Russia may be owned by an SDN. So what all of these measures together really has meant over the last several months is that the compliance burden on folks like you has become intense. And as Allison mentioned, it does not appear to be going away anytime soon. And I think we can probably expect not only additional actions in these buckets of measures, but perhaps additional approaches to sanctions as we move forward. With that, I think I'll pass it over to Brian for an overview of the Canadian measures.
Thanks, Terry. In Canada, as Allison sort of mentioned at the start, since February 24th, we've just seen an unprecedented number of amendments being made to the sanctions that have been imposed against Russia. And in our sanctions legislation, at a minimum, while we expect always to see sanctions being imposed against designated persons, we've seen a staggering number of individuals and entities named as designated persons, particularly Schedule I designated persons, where the prohibitions are the most restrictive. As of the most recent amendments that were passed very recently, we now have a total of 849 individuals and 235 entities on Schedule I as designated persons. we've not seen that before under any other sanctions program. One thing to mention about that, though, is, Canada was kind of at the forefront in some respects for some of these designated persons, and that many of the Russian banks were named as Schedule 1 designated persons in Canada before having similar designations in the US or the EU, for example. Canada's been very aggressive in adding to this list, and the number of entities on the list cover a wide range of enterprises in Russia, making it very difficult to do a lot of commercial transactions in Russia. And in looking at the slide, apart from the oil exploration or production prohibitions under Section 3.3 of the Special Economic Measures Russia regulations, all of those other prohibitions that you see there have been enacted since February 24th. A lot of those measures are measures that we've not seen before. It's a new approach that our sanctions regulator, Global Affairs Canada, has been taking. I know a lot of you in the audience have maybe spoken to me, and we've talked about that, for example, the restrictions that have come into effect pursuant to 3.6 that talk about this restricted goods and technology list. That's a new way of controlling for export certain goods and technologies. We've not seen that before under any of our other sanctions programs. The prohibition on services to certain industries, which was brought into effect a few weeks ago and further amended recently, that's an entirely new approach that Global Affairs Canada has introduced into a sanctions program. And as some of you may already know, one of the challenges we've been experiencing historically with our regulator in Canada, and it's become more pronounced as a result of the sanctions against Russia, is that our regulator does not publish guidance with respect to its views or interpretation or application of the sanctions. And that leads us a lot of times to a lot of uncertainty, because we have terms like owned and controlled and for the benefit of or on behalf of, where we don't have a very clear direction or guidance from our regulator. And when we've had informal discussions with them, I mean, their position consistently has been the language of the sanctions is broad, and it should be interpreted and applied that way. And that makes it very challenging for compliance, given that uncertainty, particularly since in Canada, violation of the sanctions can lead to criminal offenses. It's a criminal offense. And so when we're talking about criminal offenses, folks would like to actually have some certainty. And so what that has resulted in is a significant number of permit applications being submitted to Global Affairs Canada, because through the permit application process, that's really been the only way we've been able to try and get certainty on whether the sanctions do or don't apply to some circumstances. And you would think that, because of that sort of fact or that circumstance, Global Affairs Canada would be a little bit more prepared to have dealt with the influx of permit applications they would receive. It's a small group of people that work there. I'm told they have hundreds and hundreds of permit applications that they have to process. So the system has been slow. Getting responses back from the regulator has, in some instances, taken weeks. So we'll see how all of this sort of works out. I would like to mention something. Recently, the legislation was amended to allow Global Affairs Canada to start issuing general licenses or general permits. This was something that the Trade Bar has mentioned to Global Affairs Canada as something that a US-style general license would be perhaps useful. Legislative amendments have been put in place to allow for that. That bill has been passed. So conceivably, we could maybe see some general licenses or permits being issued, but so far, we haven't received any indication or signals from Global Affairs Canada that they would be moving in that direction, but something certainly to keep an eye on. With that, I'd like to turn things over to Ben.
Yeah, thanks, Brian, and hi to everyone. So a very brief summary on the EU, Swiss and UK sanctions positions. We've grouped them together for brevity. There are a lot of similarities, as there are with the Canadian, the US, Australian and other sanctions regimes, but there's some material differences as well. So to recap, the UK now, post-Brexit, has its own standalone sanctions regime, and we have seen some material differences. While there have been similarities, we've seen some key differences between the UK and the EU. So the UK has been a bit slower in some cases. So, for example, we'll talk about the UK investment ban that came in on Tuesday, the UK services ban that came in this morning. Both of those were lagging somewhat behind the EU. Whereas on the other hand, the UK has been a bit quicker and broader in the parties it's sanctioned. So there's some really key differences. There's different guidance, there's different exceptions, licensing grounds. The UK, similar to what Brian mentioned, has now a regime for general licensing. So we have general licensing here in the UK where there isn't that in the EU. On the Swiss side, for the first time, Switzerland has imposed sanctions against Russia. Previously, they were anti-circumvention measures, and the Swiss effectively have been adopting the EU packages of sanctions after a period of weeks after the EU will roll out those sanctions. Very similar to what's been described in terms of the US and Canada, we've seen wave after wave of sanctions. So today, the EU has issued its 7th package of sanctions, the details of which are slowly emerging this afternoon. The UK as well has issued a number of new sanctions today and on Tuesday, and we don't see, as Alison mentioned, we don't see that stopping. There's likely to be further sanctions going forward. We'll do a deeper dive into some of these buckets, but very similar to the other regimes, we've got a long list now of designated parties. In our jurisdictions, we have a control test as well as ownership, so it isn't the same as the US bright line 50%. A number of sectors have been targeted by new and often innovative sanctions: finance, defense, energy, aviation, media, and beyond. So there's a raft of sanctions across a number of different industries. We've seen targeted and new and innovative financial sanctions that impact certain payment structures or dealings in shares. We've seen a broad ban on services that we'll talk about, a broad ban on investments and slight distinctions, EU and UK, a whole range of export-related controls and related services, so any services relating to the supply of controlled items, huge long lists, often linked back to customs codes. Similarly, mirroring that, we've seen import controls, so we've seen more come in today in the UK. For example, in respect of oil, that will come in at the end of the year. Coal will come in next month. Gold as well, a number of other import controls. The EU reportedly today is issuing sanctions in the imports of gold from Russia. So a number of different export and import regulations, and then various other sanctions, including very extreme measures relating to Crimea, Donetsk and Luhansk. It's a very similar picture, a range of different sanctions. I think we're going to pass back to Alison for a deeper dive into some of the different buckets.
Thanks very much, Ben. Okay, so that was sort of the 10,000 foot view. So let's dive into a couple of the sort of trickier areas where we get quite a lot of questions. We're going to start with the product controls, and I'll just kick off for the US. So obviously, we've had for some time now the Russian military end use controls in the EAR. We've had the industry sector controls. We've had the export effectively embargo for Crimea, etc. Then in early February, early March, BIS significantly increased the types of products controlled for export, re-export or transfer within Russia. And that was also expanded then to Belarus as well, which we shouldn't forget. So, and this is all under 746.8 in the EAR. The baseline requirement now is that all CCL, all commerce control list items, including AT controlled items, are now licensable for Russia and Belarus. The only exception is for mass market 5A, 5D, 992 items, if they are going to certain sort of friendly end users, which is essentially, in a nutshell, US or A5, A6 country group affiliated end users, like wholly US owned subsidiaries or companies headquartered in A5 or A6 countries. In addition to that, we have expanded jurisdiction over foreign items, foreign-made items. Firstly, the de minimis rule. So now for purposes of the EAR de minimis rule, you have to count additional controlled US origin content. There is an exception. So if the foreign-made product is being exported from one of the 37 excluded countries in supplement 3, like Japan, Korea, EU, Canada, etc., and the US origin content is only AT controlled or 9A991, you can ignore that US origin content when you're doing your de minimis jurisdictional analysis. Then also for foreign products, we have 2 new foreign direct product rules. One is what we'd call the general Russia-Belarus foreign direct product rule, which applies, as Paul mentioned, in yesterday's export control section. For the foreign direct product rule, you have 2 elements to it. You have the product scope and you have the destination requirement. So under this one, for the products, if you have a foreign product, as long as it's not EAR 99 and it's a direct product of US origin technology or software under any ECCN, or again, as long as it's not EAR 99, but it is produced by a plant or a major component of a plant outside the US, that is itself a direct product of US technology or software in any ECCN, and you know that it's going to Russia or Belarus or for incorporation into a product for those countries, that again is not EAR 99, then it's caught by this new foreign direct product rule. So that's the sort of general Russia-Belarus foreign direct product rule. There's a second military foreign direct product rule for Russia and Belarus, which includes EAR 99 foreign products. Essentially the same types of rules in terms of the product scope, but as I said, if the foreign product is EAR 99, it's caught. On the end user side, you have to have knowledge that the item is destined for an entity that has a footnote 3 entry on the BIS entity list. So what's happened there is that BIS has moved Russian military end users from the military end user list over to the entity list and designated them with a footnote 3. So those are the ones that you need to watch out for. If you have a foreign direct product under either of those 2 limbs, then a license is required unless you're exporting from one of those 37 excluded list countries. And the reason for that is the multilateralism here and the expectation that those countries will be controlling exports from their jurisdictions anyway. And so there's no dual licensing need. It's an interesting question as to whether this may herald a broader change in approach towards those 37 excluded countries. So aside from the expanded jurisdiction, we've also seen a narrowing of the license exceptions. For example, ENC has been narrowed to certain types of civil end users. AVS has been removed for aircraft going into and out of Russia, which is why we have seen quite a few temporary denial orders and listing of aircraft under General Prohibition 10, because those aircraft, if they're subject to US jurisdiction, can no longer fly into Russia, as that is an illegal export. We've also seen some expanded industry sector controls. So 746.5 is where you'll find those. That used to cover more sort of stuff for sort of oil field drilling, etc., for use in restricted energy projects, but it now includes various industrial machinery, bulldozers and things like that, all in supplement 4. So, and that includes some EAR 99 items. So that's it from the US side. Brian, could you address for Canada the product controls?
Sure, thanks, Alison. In Canada, sort of at the very start on February 24th, Global Affairs Canada and the group within the department that's responsible for Canada's export controls program, announced that it would be it would no longer issue export permits for any goods or technologies subject to export control under the Export and Import Permits Act. For those of you familiar with that legislation, those would be items that would be described in what's called the export control list, or a guide to Canada's export controls. As well, at the same time, they canceled any valid and existing export permits for controlled goods. Subsequent to that, we then saw the introduction of this restricted goods and technology list. This was sort of done in coordination or following similar measures that the US and the UK took. The restricted goods and technology list, if you look at it, references a guide to Canada's export controls. It certainly covers a lot of dual use items and technologies that would not be subject to export control under the Export and Import Permits Act. So for example, categories there include certain electronics, computers, telecommunications, cryptography, avionics, sensors, and so on. One interesting thing to note, I had a discussion subsequent to that prohibition being introduced. I contacted someone at the Export and Import Controls Office at Global Affairs Canada to understand that if there were questions about interpretation or application of the restricted goods and technology list, would that be something that his office is handling, or whether the sanctions group at Global Affairs Canada would be handling. And he confirmed to me that it's entirely within the sanctions group to interpret and apply those export controls under the restricted goods and technology list. So something to keep in mind if you're looking at that list. Subsequent to the RGTL, we also saw some additional product controls come in. Just a matter of a few weeks ago, I think at the end of June, we saw the introduction of Schedule 5.1, an additional set of technologies focused on quantum computing, semiconductor production equipment, a very short list, but a very targeted list described by Global Affairs Canada as items that could be used in the manufacture of weapons. We've also seen prohibitions on the export of or the import of petroleum products and goods used, or petroleum products and goods used for oil exploration and production. Certain goods, there was a particular prohibition in the sanctions that was introduced that talks, it was described as being a prohibition against the export of goods used for the manufacture of weapons. And certainly if you look at the provision within the sanctions, that's the title to the section. However, there's no such requirement in the provision itself. So it doesn't actually refer to the goods having to be used for the production of weapons. And that's presented some problems, because if you look at the schedule in which those goods are described, what they've done there is they've referred in part to very broad headings or categories of goods, cross-referencing those to the Canadian customs tariff, although indicating that the customs tariff provision is there only for reference purposes only, and then leaving us to assume that what is described, or if something can be described in the heading, then it can clearly potentially be subject to prohibition. I only call that out because, for example, in that prohibition, they listed essentially electronic goods under Chapter 85 of the customs tariff. And that is quite a large chapter and includes a lot of items that are not just for the manufacture of weapons. And so this prohibition could actually appear broader than it seems, and why I noted that on the slide. More recently, as a result of the meetings amongst the G7 countries, we saw a prohibition against certain gold products. There again, I would say, when you take a look at the prohibition, it does appear broader than it seems, because again, it applies not only to certain gold products, but in some instances, other precious metals as well. So if there's one thing I can say with respect to the product controls, many of them are new, many of them are novel. It's very important to carefully review them and understand that in some instances, they do appear broader than they seem, and perhaps even broader than the way Global Affairs originally described them when they announced them as part of announcing, the most recent amendments or amendments to the legislation. With that, I'd like to turn it over to Ben to discuss the UK-EU.
Thanks, Brian. And yeah, again, a very similar story in the UK, the EU, and also Switzerland. We have, both in respect of the very long lists, a number of controlled items, a number of annexes, schedules to the relevant regulations, listing a huge long list, but particularly by customs code. And likewise in the breadth, in terms of the breadth of the control. So it's not just a plain export, and it's important to remember also that dual use and military export controls apply behind the sanctions still. So you may get comfortable on the sanctions side from dual use, but you may still have export control, classic export control issues. But they're very broad in their application. It's not just moving items from the UK or the EU to Russia. It can be indirect. So there's a focus on due diligence and contractual protections, and it can also capture broader activities. So the sale or the supply, in the UK, making available, the transfer, transport in certain cases, and then related services. So classically, you've got technical assistance relating to controlled items, financial assistance, financing and financial services relating to controlled items. And a new control we've seen in the EU is any other service relating to certain controlled items, which is described as comprehensive. So really it's incumbent upon any businesses doing business relating to Russia to understand, are there items on these lists and which of these laws applies? And behind the controls, there's a number of exceptions, a number of licensing grounds. They all differ across the different regimes and between the UK and the EU. So relying on exemptions or applying for licenses or relying on general licenses, you need to be very, very careful you're squarely within the scope of those exceptions or licenses. So we talked a lot about the breadth of product controls and a number of different buckets. I think I'm going to hand back to Brian now to zero in on the luxury goods controls.
Thanks, Ben. One area that we've seen a little bit of divergence in, and this question comes up a lot, or sometimes clients ask, they say, I thought Canada implemented the same set of controls as the US or as the UK EU. The ban on luxury goods, both an export ban and an import ban, is kind of an area where you see a little bit of divergence in terms of how the jurisdictions decide to implement controls. The way that Canada did it, again, kind of broad brushstrokes. In terms of the export ban, they listed essentially 257 categories of luxury goods that are subject to an export ban, and then a further 26 category of goods that are subject to an import ban. And in listing those items, if you take a look at them in the schedule, they did provide a reference to the harmonized commodity description and coding system number. So an HS code is part of the schedule, but then footnoted that to indicate that that's provided for reference purposes only. And so why do I mention that? I mention that because as the HS code, at least for Canadian purposes, is provided for reference purposes only, you can't simply look at the HS code to decide whether your good is subject to the export ban. If your good satisfies the description of a category that's in the list, we've been taking a conservative position in it, saying that that would be an item that is subject to this export prohibition. This has come up quite a few times. And as well, in Canada, there's no exceptions made for certain end uses. So if a product happens to be a cosmetic but might have a medical end use, there's no exception made for that. And as well, Canada took an approach a little bit different from the other jurisdictions in that it didn't implement a financial threshold for this export ban to apply. So whether your cosmetic is worth $2 or $2,000, if it's described on the list, it's subject to the export ban. And that's been certainly a different strategy and a different take that Canada has had from the other jurisdictions. Alison, maybe you'd like to comment on the US approach.
Yep, thanks, Brian. So the luxury goods ban under the US rules, there are essentially two or rather three elements to it. And these are obviously in addition to the CCL controls that I mentioned earlier. The first is under the EAR. There is a broad ban on the export, re-export or transfer by anybody of luxury goods that are subject to the EAR to or within Russia or Belarus. There's a similar related EAR ban for same luxury goods to certain Russian or Belarusian SDNs anywhere in the world. The only license exceptions are baggage and AVS, which is a little bit different to the general CCL controls. The licensing policy is flat denial. Then the third element is actually under the OFAC rules under Executive Order 14068. And this is a ban on the export re-export, sale, or supply by US persons of any type of luxury goods, regardless of origin, regardless of whether it's subject to the EAR, to anybody who is located in the Russian Federation. Now, the OFAC ban, interestingly, has not been extended yet to Belarus. So that is one important difference, and there are no exceptions under that OFAC ban. All three of those, so the 2 EAR and the 1 OFAC luxury goods ban, all tee off the same list of luxury goods, which is in Supplement 5 to Part 746 of the EAR. And unlike for Canada, there are some monetary thresholds, particularly for footwear and apparel. There are about 31 or so broad categories, which are described by Schedule B number, the 2-digit chapter heading, and the 10-digit description, which is a little bit less information than you get under the industry sector controls, where you also get the HTS description. So as Brian says, can be a few difficulties in figuring out what's actually covered. Ben, do you want to give the EU UK version?
Yeah, thanks, Alison. And so again, we have broad alignment between the EU and the UK. The UK was a little bit behind the EU here, and we've seen those extended, the luxury goods control, recently by the UK to Belarus. We're awaiting the EU to do the same. In certain respects, they're slightly narrower than the US and the Canadian list. So they don't just list entire categories of customs codes. There is a long list between 22 different types of luxury goods, and they're all identified by a specific customs code and a specific description, and you've got to look at both of those. And as Brian alluded, there are also certain thresholds. So as a general rule from an EU perspective, for example, there's a threshold of items that are worth more than 300 euros with the price calculated per the guidance at the time of export. Certain items have bespoke thresholds. It's important to look exactly at the controls and what applies in terms of the item, the thresholds and the activity. The related services aren't quite as broad. That's one distinction to the other product controls from the UK and the EU side. But again, there's a long list of items, very much modelled on similar luxury goods controls the UK and the EU has for Syria and for North Korea, for example. So that was luxury goods. If we can advance to the next slide, we're just going to talk a little bit about the investment side of things. I think Alison's going to lead on this one.
I think I was going to take this one. Thanks, Ben. So one of the sort of the hallmarks of the U.S. program has been this prohibition on new investment in Russia under 14071 that was implemented in early March. And one of the big questions that clients had was, well, what does this mean for U.S. companies that may have operations in Russia? I mean, most U.S. persons are not looking to make investments in Russia at the moment. And OFAC defines investments as commitments of capital or other assets for the purpose of generating returns or appreciation. But many U.S. companies are doing things like supporting subsidiaries that are operating in Russia lawfully, etc. So with the new investment prohibition comes two sort of key carve-outs. And the first is a carve-out for maintenance of pre-existing operations. So the guidance has been, and as it's been interpreted, is that U.S. companies do not violate the new investment prohibition, where they provide support, be it funding, etc., to assist in the day-to-day operations of that U.S. subsidiary. And the test generally has been, when we look at these issues, is, is the funding or is the support designed to sort of expand the operation in Russia? If the answer is no, then we say that commitment of assets or that commitment of capital does not run afoul of the 14071 prohibition. So, for example, if a Russian subsidiary operates a manufacturing facility and the HVAC system has gone out in the facility, well, the U.S. parent can make a cash injection to that subsidiary to fix that HVAC system. under this sort of maintenance carve out, because in that case, the idea was not to expand the operation, but to simply keep the existing operation afloat. And OFAC has been consistent on that, not only in the guidance that it published subsequently, but also in informal guidance that is provided. The other key carve out relates to divestment activities. So where a U.S. headquartered company is looking to divest its asset in Russia, and in connection with that divestment, and many of these divestment transactions are very complicated, they may need to engage in a transaction that in a vacuum looks like new investment, where that's necessary to sort of facilitate this investment. OFAC has said in guidance that transactions that relate to the divestment of a company that's owned by a U.S. person do not trigger the new investment prohibition. This issue often arises in the context of maybe delayed payment terms for a buyer, et cetera. And just the last point, because we probably need to get moving, is that it's clear that the new investment prohibition restricts U.S. persons from purchasing securities that have been issued by Russian companies. Immediately following the issuance of the order, that wasn't entirely clear. OFAC has now come out in guidance on that point. I'll pass it over to Brian to talk the Canada piece.
Thanks, Terry. Just very quickly, we have not yet seen a prohibition on new investment in Russia. Again, I say not yet because amendments to these sanctions keep coming out almost every other week. However, I will say that because Canada has been very aggressive in adding to the list of Schedule I designated persons, and given the broad nature of those prohibitions against Schedule I designated persons, those prohibitions make it difficult to conduct investment in Russia. Again, it may involve certain parties, certain Russian financial institutions, and because they've been named on Schedule I, it's difficult to do. It's difficult to do any new investment in Russia. There's also no sort of exception made for new investment or even divestment or wind down. That's also been a bit of a challenge as well. But again, we'll see whether in the coming weeks we'll have a specific investment prohibition. We do have similar types of measures and other sanctions programs. We just haven't seen it yet with respect to Russia. Ben, I'll turn it over to you to comment for the UK and EU.
Yeah, thanks, Brian. And very quickly, we saw early on the EU roll out energy sector specific investment controls, and they're very, very broad in nature. We've waited some time in the UK, but this week on Tuesday, we saw a broad UK investment ban come in, effectively applying across different sectors, so not targeted only on energy or otherwise. So, and alongside those energy EU sector investment restrictions and the broad UK ban, there's a range of other controls applying to certain movements of funds to and from Russia, including public financing, certain dealings similar to Terry's description in terms of sectoral controls. So from a UK perspective, there are effectively restrictions on loans, credit, or dealing in the securities of any Russian entity at all, with certain limited exceptions, such as foreign-owned Russian subsidiaries. And then we have extended investment restrictions relating to Crimea and the non-government controlled areas of Donetsk and Luhansk. So very similar story in terms of Canada and the US. There are very broad investment controls, and those have greatly expanded this week in the UK with the new investment ban. That's in terms of investments. I think the last of our kind of thematic look at the different types of sanctions is the services prohibition. So again, this is a new and innovative restriction. We saw an announcement through the G7 back in early May that the US, Canada, UK, EU and others would be bringing in certain services prohibitions targeting certain accounting and professional services. And we've seen a bit of a divergence in how quickly these have come in. So from an EU perspective, for over a month now, we've had relatively broad controls relating to certain accounting and tax consulting, certain business management consulting services, and certain PR services as well. They're defined quite broadly in the regulations, and there are certain international classifications of services sitting behind the definitions where you can get a bit more detail on what exactly is covered. The EU guidance suggests it's not just service providers who are specialising in providing those services to third parties, but it can also capture in-house services. So a number of companies have been reviewing and assessing the services that are provided. We have waited some time in the UK, and this slide is now out of date because we have seen as of today the equivalent UK services restriction come into play. On the EU side, there is an exemption for EU-owned entities in Russia. And at the time of speaking, from a UK perspective, we haven't seen that replicated. So we're just waiting to see some guidance and potentially whether a general license may come out. But those controls are relatively broader than in the US, for example, in some respects, with the lack in the UK of any exemption for UK-owned entities. The Swiss have followed the EU as well. So a broad range of controls and relatively similar. So I'll pass over to Terry to talk about the US side of these controls.
Sure, thanks, Ben. So Executive Order 14071 contained a provision that authorized OFAC to prohibit the provision of certain services to persons in Russia by U.S. persons. Pursuant to that authority, OFAC issued a determination identifying essentially 3 categories of services similar to the ones Ben just described: accounting, trust and corporate formation, and management consulting services to persons in Russia, with some exceptions for certain auditing services and credit rating services under a general license that expires in late August. Two of the issues that have arisen is, one, this concept of management consulting services, which is very broad and can presumably capture a number of services, activities that one might not typically consider management consulting services, brand management, etc. One of the key points, however, of the services prohibition is that there is an exclusion for the provision of services to persons in Russia, to entities in Russia where those entities are owned by U.S. persons. So for U.S. headquarters companies that have subsidiaries in Russia, that's sort of a key carve out and makes clear that those companies can continue to provide these services. One of the issues that arises in particular in connection with trust services is where you might have a trust structure that's located somewhere in Europe, say Liechtenstein or some other jurisdiction, and the beneficiary is in Russia, or some other relevant party to the trust structure is in Russia, the settler, protector, what have you. The key inquiry there then becomes, you may, as a trustee or be providing services to the trust that maybe sits in this other jurisdiction, but are the benefit of your services being realized by someone in Russia? And if the answer to that question is yes, then we're generally taking the position that that those types of services are prohibited, and it does lead to some some difficult questions when we're trying to determine where sort of the benefit of services might be realized. Brian, you want to quickly talk about Canada?
Thanks, Terry. We've seen the introduction of a services prohibition under the Russia sanctions. Again, a measure that we've not seen Global Affairs Canada use before in any other sanctions program. Essentially restricts the provision of 30 categories of services, some very broad in relation to 15 industries, to Russia or to persons, any person in Russia. And what's interesting about the way Global Affairs Canada implemented this measure is that the services are described. So again, there's a schedule that describes the service in one column, and in the other, it makes reference to something called a CPC category number. And the CPC is a reference to the Provisional Central Product Classification published by the United Nations in 1991. And it's very important that we talk about exactly that it's 1991, because Two reasons. Unlike the references of the use of HS codes as references in some of the other schedules, this CPC category number is not indicated to be for reference purposes only. And so we've taken that to mean that Global Affairs Canada is maybe signaling that we should be looking at that CPC category document to understand what these services could entail. And when you go to the United Nations website, you'll find several versions of that provisional central product classification document that have been published over the years. It's very important that you look at the 1991 publication, which is probably the very first publication of that document. And within that document, it's a very interesting document to read. It sort of tries to provide some explanation of how broad these service categories are. So engineering services, for example, is one of the services that are listed in the schedule. And when you read the CPC document, that's a very broad category of things that could fall within engineering services. There's also architectural services, computer and related services. And because of the CPC category number, and this is why I think it's important, in some instances, the category number can refer to a very broad sort of division within that list, and it can encompass a lot of different things that you may not have thought could fall within, for example, computer and related services. So very unique way of Global Affairs Canada approaching this. Something to be very mindful of when you're looking at that provision, or if you're trying to understand how it could apply. Very important that you're looking at those documents that are cross-referenced in the schedule. There are very limited exceptions made for the provision of services. In the most recent amendment that was passed to add to the list of services and industries, there was a bit of a carve-out made for certain for the provision of certain services, so that the prohibition would not come into effect for those services for at least 60 days. And in the note that was published in the Order in Council that enacted these regulations, Global Affairs Canada indicated that was for the purposes of allowing those contracts to wind down. So query whether that might signal to the trade bar that if that's being done to wind down, Global Affairs Canada might not be interested in entertaining permits to extend those contracts. Again, that's speculation on my part, but just something to keep in mind. With that, I'd like to turn it over to Alison to maybe talk about some key compliance issues in the sanctions space.
Thanks very much, Brian. So those were some of the sort of key themes, and now we're going to touch very briefly on some of the more practical compliance challenges associated with payments and also with divestment and restructuring. So for this, perhaps I can turn to Terry first and then Ben. Thank you.
Sure, Alison, thanks. And I think we'll move quickly through this slide. And I think, yeah, payments have been an issue, and sort of, I guess, interestingly, I think the reason why payments have been such an issue probably have nothing to do with the items we put up on this slide. I mean, certainly there are a number of SDN and designated party banks that are subject to asset freeze. It's clear US persons, EU, UK persons can't engage with those banks, can't be involved in the payment activity with those banks. We know that there have been a number of banks that have been removed from the SWIFT network. Clearly, those banks, and most of them are SDNs in the US. In any event, there are Russian countermeasures that prevent certain funds to flowing outside of Russia. Maybe Ben in a minute can talk about some of the EU, UK remittance restrictions. But I think what's really boggling the sort of the Russia-related payments is everything we've talked about up to this point. Because it's easy for banks to understand that, well, if they see an SDN on a transaction, they have to block that payment. But what banks are really concerned about is that they're not facilitating through a payment an activity that is otherwise prohibited under the Russia sanctions. So I think the message there is that when dealing with financial institutions, and you're engaged in payment activity involving Russia, be prepared to have to explain to that bank, this is a Russia-related payment. this is why this payment is compliant with U.S. sanctions, and have that at the ready, and that that should smooth the process of getting funds to Russia and also outside of Russia. Ben, do you have anything to add on this?
Yeah, no, clearly funds transfers both ways are becoming increasingly challenging from a practical and legal perspective. Just to round out the bullets here, the EU and the UK, as part of those new innovative measures, have also increased or added certain restrictions on banks accepting deposits from certain Russian nationals, and now it's been extended to cover entities controlled by certain Russian nationals. So a number of different payment challenges to work through for any payments to or from, and it's becoming increasingly difficult. If you can move on to the next slide before we then move on to Ukraine, we just wanted to touch base on divestment or restructuring. Obviously, the sanctions have had an enormous impact, as have a range of other practical and commercial factors. And we've seen many businesses announce certain wind downs, withdrawals, sales, etc. We've seen a range of different options being pursued, and a point here we wanted to make is there are a number of sanctions considerations when assessing what you're doing with, for example, your subsidiary or branch that was in Russia. There are controls around issuing shares in new entities, for example. We've talked about the payment restrictions. There are certain sensitivities around IP in terms of whether IP is being withdrawn or whether it will continue to be licensed or whether it be sold. And we're seeing challenges through those product controls and services controls. Many companies obviously rely on a network of group IT functions and related services, and we're seeing some of these new and innovative controls capturing those, as well as on top of that, and we have a separate session later on the Russian countermeasures. So there's a whole range of different sanctions and broader practical considerations when assessing what you may be doing with your Russian business, whether that's a wind down or a sale or otherwise. A number of challenges, a number of considerations, and a number of complexities to work through. So I think now we'll hand over to Hannah, and Hannah will walk us through the Ukrainian position.
Thank you, Ben. I wanted to start with a map and explain a little bit different status of different territories in Ukraine, starting from the February 24th. So as you see, the bright red territories marked on the map, these are the territories that have been annexed or outside of control of Ukraine before 24th February. And this is so-called Donetsk and Lugansk People's Republic and the Crimea, which have been banned under the US, UK and other sanctions. And there's always a question whether the whole Lugansk and Donetsk regions fall under the ban or not. And actually it is not, because the exact list of territories which constitute Donetsk and Lugansk republics were established by the presidential decree. And since then, since the beginning of the 4th of February, they haven't changed. The light red territories, which you can see, these under Ukrainian law considered to be areas of military combat operations. They change, they move, and this is not only Donetsk and Lugansk regions territories, these are also other regions. So when it comes to a practical perspective, what you do with these territories and how you deal with Ukraine and Russia in respective of these territories. From the Ukrainian law perspective, this, if anything is supplied to these territories from the territory of Russia, this will be a severe violation, not only a smuggling, but it can be a criminal offense and can fall under different criminal offenses under Ukrainian law. So irrespective whether this is Donetsk or Lugansk People's Republic, so these are all other regions which are temporarily outside of control of Ukraine. And as you see on the next slide, the prohibitions applicable are very broad, and illegal trade with these territories through Russian subsidiaries or through Russian counterparties can be recognized as financing of terrorism, can be recognized as a criminal offense of collaborationism, and result in criminal liability and measures of criminal liability, both for the foreign companies and individuals, not only for Ukrainian companies and individuals. Therefore, we recommend to provide in your contracts with your Russian counterparties and with your Russian distributors a clear prohibition to provide any goods, services, or works to the temporarily occupied territories of Ukraine. At the same time, it's important to analyze every case separately and not to do over-compliance when actually Ukrainian companies continue an operation under very difficult conditions on the territories which actually are not yet occupied and not yet directly affected, cannot continue their business operations because of over-compliance with the sanctions. And another important thing to understand that even these territories which are now the zone of active military actions, first of all, it changes every day, and a particular town can be day-to-day change its status. And also after some time, it's not clear whether these particular towns and cities will be actually these Donetsk and Lugansk People Republics, or they will be something different, which is not yet encompassed by particular sanctions against Donetsk and Lugansk People's Republic, but might be encompassed by the sanctions against Russia. So cautious analysis is required when you deal with anything related to these territories, and Russian businesses and Russian counterparties should be clearly prohibited in the contract by doing anything on this territory, supplying there. In addition to this, on the next slide, I wanted to share with you a few novelties of Ukrainian legislation which affect not only Ukrainian operations with Russia or Ukrainian trade with Russia, but broader, aiming to stop any international companies doing any business in Russia. And these new developments, legislative changes, were affected under the new stage of full-scale Russian invasion of Ukraine. And the first was, of course, two mechanisms of expropriation of property. It started with the law that allowed expropriation of property only of the companies that had a share owned by Russian state, either directly or beneficially. Later, there were approved by the parliament amendments to embroader it and encompass also Russian residents, which are not Russian state. At the same time, this draft law was not was approved by the parliament, but not signed by the president yet. So it's not yet effective, but might become effective. And this new mechanism of expropriation was already tested because two cases have been that two Russian state-owned banks have been expropriated in Ukraine. But in addition to this, the Ukrainian government looks at this war in a way that any company that for example, interest-free loans, donations, like charity contributions, investing in Russian governmental bonds, is actually financing against Ukraine. And changes to the sanctions law were introduced to allow expropriation of any companies that are on the sanctions list and conduct activity that can be considered as financing of armed aggression, to expropriate their property located in Ukraine through a court procedure. So this is a major development, not only to allow expropriation of sanctioned property, which didn't exist in Ukraine before, but also it defined what facilitation of Russian aggression is considered in Ukraine, and it's quite broad. It's not only by supplying or providing something directly to the Russian state, but actually it's a mere conduct of business activities under some circumstances, like paying tax by Russian companies or providing assistance, for example, to Russian subsidiaries of international companies, can be considered as well financing of armed aggression against Ukraine. And the third novelty was criminal liability for collaboration with the aggressor state. So first of all, at the moment, only Russian Federation is declared as aggressor state. Belarus is not yet declared as aggressor state. But this criminal offense allows to bring to liability not only individuals, but also to criminal liability measure companies, as well as foreign companies. And it defines one of the ways of collaboration is actually carrying out commercial activities in cooperation with the Russian Federation. So any joint ventures, any supplies for public needs, any supplies for military or state-owned companies are likely to fall under this prohibition. And of course, these are not supplies from the Ukrainian territory, but from abroad. And this opens very broad potential for liability of companies which are not located in Ukraine. We have a possibility to review criminal cases like without being present in the country under the law. So these three novelties created an opportunity for the Ukrainian enforcement authorities and governmental authorities to go after companies, international companies, that may be present or not present in Ukraine, but continue business in the Russian Federation. And on the enforcement, so it's relatively new. From the sanctions perspective, there was not yet enforcement. On the expropriation, there were 2 cases of enforcement. On collaboration, we know that there are 500 criminal cases on collaboration. However, we don't know the details who exactly was encompassed. As well, Ukrainian government and Ukrainian authorities, including enforcement authorities, were very much preoccupied with everything else that was going on and investigating other crimes of war happening. So there is a certain, we think, delay in investigation, which can resume once more normal operation of the authorities will resume. And we know that there is it's public that there is new head of prosecution office, a new head of security service stepping in, and the enforcement practice may change, so there may be increase in the enforcement practice. Next slide, please. In addition to this, there are other restrictions against Russia introduced, but also affecting international companies. And I wanted to mention the new law providing for cancellation of marketing authorizations of medicine manufactured in Russia and Belarus and or commercialized by the companies affiliated to the companies with pharmaceutical manufacturing facilities in Russia and Belarus. So this is a very broad prohibition which was targeting any multinational pharmaceutical companies that continue their operation in Russia and were present in Ukraine. So the law is effective. At the same time, the procedure for cancellation of marketing authorization is not yet approved. And once it's approved, it will be clear how it will work. Now we understand there is a lot of negotiation between the European authorities and Ukrainian authorities, how it will work. And it's expected to be approved within the next few months. Next slide, please. So on a few words on Belarus. As mentioned, as of now, Belarus has not been recognized as the aggressor state in Ukraine. However, there are separate restrictions applicable to operation with Belarus, in addition to similar as for Russia for marketing authorizations and for ban of use within Ukraine of medicine that were manufactured or registered on the territory of Belarus. There are payment restrictions. At the same time, we know that there are lobby and willing to actually recognize Belarus as aggressor state, and in such case, all restrictions applicable to the aggressor state, at the moment Russia, will also be applicable to Belarus. So on the next slide, I want to mention a few key takeaways for the companies, irrespective whether you do business in Ukraine or not. We don't recommend to allow your Russian counterparties to supply anything to the temporary occupied territories. It's a risk of criminal liability. In Ukraine, it's a risk of violation of sanctions. You should be very careful how you deal with these territories, and having a special provision in the contract would be very helpful. For companies which consider doing business in Ukraine in the future, the only risk-free option for operations in Ukraine is, of course, termination of their business operation in Russia and Belarus, because currently any activity there can be considered either as collaborationist activity or financing or facilitation of Russian aggression against Ukraine, and can either lead to criminal liability or impossibility to continue business in Ukraine. It's important to screen against Ukrainian sanctions, and not only when you deal with Ukraine. Ukrainian sanctions target not only from economic perspective companies and individuals, but also a lot of individuals and companies that breach the ban for doing operations in Donetsk and Lugansk People's Republic, and actually declared either as terrorist or terrorist organizations. So they give a broader view on compliance. And we recommend to revise contractual arrangements and standard compliance provisions for Ukraine, and also for your Russian counterparties, to clearly prohibit restricted operations in case of any investigation started in Ukraine, so that you have defense and could use these provisions as defense for both your companies and your offices in the companies from criminal liability. With this, I pass over to Anne.
Thanks so much, Hannah, for that. And we thought we'd finish up with looking at Asia Pacific as showing that there is a real lot of divergence in sanctions approaches. Starting with Australia, Australia has the most comprehensive sanctions regime against Russia in Asia Pacific, and in part that's because measures were introduced in 2014. So one of the first things that happened earlier this year was expanding measures, for example, that were implemented regarding Crimea and Sevastopol to Donetsk and Luhansk. And so, Australia was able to do that. Where we've seen the most activity, though, has been in designated parties. So what has happened since February this year is, there are hundreds now more designated parties. I can take the advantage of comments made by others earlier, particularly a lot of the comments that Brian made about the Canadian regulations, in that being, more limited guidance being given. So same sort of thing applies to Australia in trying to identify the scope of the designated parties, and they're fairly broad prohibitions on providing assets to benefit or dealing with assets owned or controlled by a designated party. We don't have a general licence scheme in Australia, and there hasn't really been a lot of practice for people seeking permits. So it does mean that there needs to be a fair amount of interpretation about what is actually the intended scope of these provisions. And, this is where the Australian government has been most active in issuing sanctions measures. That they've done that sort of through the sanctions regime we've got targeting Russia, but also utilising the new Magnitsky measures that were passed in December last year, but it's just another mechanism of doing designated party measures. So Australia has also sort of since February done a number of additional measures, not as much as Europe and the UK and the US, but still quite substantial. We don't have a targeted services ban measures that have been announced. We don't have that broader investment sanctions measure that has been announced. We're still relying on our measures for those things that were introduced in 2014, 2015. But the way Australia deals with sanction services, it ties the sanction services prohibition to your sanctioned exports, sanction imports, sanction commercial activities. So we probably have seen most activity around sanction services restrictions, even though there actually haven't been new measures introduced. It's how those measures catch other things. In the interest of time, let me move on to Singapore. So Singapore, I think the best way to sum up the Singapore sanction measures is that they really are restrictions regulating primarily financial institutions. And so that there has been an enhanced regime where the Monetary Authority of Singapore has listed 4 banks at the moment. And there are a range of restrictions, asset freezes, not dealing with assets at all, not providing benefits, doing financial transactions, mainly around these 4 designated banks. And the obligations that I'm talking about now are all sitting on Singapore regulated financial institutions. And then there's some broader restrictions that also stop those financial institutions getting involved in supporting transactions for export controlled goods. There is a structure under the Singapore instrument that's been issued. There's a structure for other parties to be designated, but no one's been designated at the moment. They of course, can be. And that structure, again, is restricting Singaporean regulated financial institutions from, dealing with parties should they be listed. The other Singapore restriction, if we move away from what regulations that are just applied to financial institutions, the main restriction that applies to everyone is there are enhanced restrictions on export transshipment, etc., of what we've listed there of the export control, strategic controls of military and certain dual use items for Russia. So not as comprehensive, but still this is a lot further than Singapore has gone before in any autonomous sanctions. I did also just want to finish off by sort of just moving to Japan as well, because Japan probably just sits between Australia and Singapore in terms of the level of measures. Japan has been quite active in introducing new measures, but still, again, not as comprehensive as say, EU and US measures. So again, sort of important, sort of if you've got transactions involving entities or involving Japan, just to sort of navigate what particular restrictions they have in place at the time, and whether new restrictions have been introduced, as we've of course been talking about in this session anyway. And then lastly, just to again, my last point, just to sort of highlight in terms of the rest of the Asia Pacific region, it is a bit of a watch this space area. New Zealand has never had autonomous measures, or certainly not in recent times, and they did pass an act a few months ago to introduce a designated party type restrictions for targeting Russia. And then you've got a jurisdiction like Taiwan, no actual new sanctions, but they've introduced enhanced restrictions on export controlled items, so strategic controlled items. So it is still very much, I guess, a moving developmental area in Asia Pacific about what different governments will do, in light of their, different trade positions that they have. So I appreciate that was very quickly taking you through Asia Pacific, but Alison, I'll hand back over to you. Thanks.
Unfortunately, we've run out of time to answer questions live. We've tried to keep up with as many as possible in the chat. I think we've got through about half of them, and we will follow up on the rest. Hopefully you found this content valuable and useful. As you leave the webinar, there will be a very short 4-question evaluation. Very much appreciate your feedback, which we do take into account. The next session will be at noon Pacific time, and we'll be seeing the other side of the coin, Russian counter-sanctions measures. So look forward to seeing you then, and thank you very much, everybody.